Empezar con un panel sumamente interesante, las formas que seducen, protección de diseños industriales.
Good morning. Thank you for being so early. Today we will be starting with our topic of industrial property. And, well, let's open the world just to start with the fire this morning.
Gracias. Hola, muy buenos días a todos.
Good morning to all of you. Thank you for being here so early. I want to thank ASIPI for the kind invitation. Just as Ricardo Fisher mentioned, we're in a panel that's called Ways to Seduce, the Protection of Industrial Designs. We have three panelists from three different places of the planet that will give us their perspective and will tell us how is the protection in each one of their jurisdictions. I'm pleased to present, first of all, Carolina Velez Zuluaga, working in Prebel here in Medellín. She's Paisa. She's a host of this beautiful city. She's an attorney of the Pontificia Bolivariana University, a specialist in tax practices here in Colombia with a professional practice of more than 12 years in topics of corporate rights, advising and assessing companies that belong to different economical sectors and a wide experience in massive consumption. At the moment, she is in charge of legal affairs in Prebel, that's been in the Colombian society for more than 70 years, and commercializing cosmetic goods. On the other side, from Spain, we have Iván Sempere, founder, partner, and co-CEO of Padima, doctor in merchandise right, and a professor of the University of Alicante. He presides the committee of INTA, and he's part of the group of the Association of Intellectual Protection for the Defense of the Brand Andema, focused in the protection of the brand and design and brands 3D. He's the author of different articles and investigations in this topic, being a teacher in different universities and business centers around the world. He was the president of the European Confederation of Young Businessmen and of the foundation company Fonde Uno. And finally, we have Natter. He was mentioning that he used to have his office in New York. Now he opened an office in Palm Beach, Florida. He's known in many forums. And basically, I'll just switch into English so he can hear his own introduction.
Bueno, lo tengo en español. Natter actúa como director.
Natter acts as a director of the Global Brands Hub Partners. His practice is focused on all the aspects and the strategies in terms of acquisition management of international national brands. Ben adapts specific focuses of the client for the protection of the rights of intellectual property around the globe. Any day you could see Ben making the rights of his clients be taken ahead around the world with local authorities, tribunals, and a team of local attorneys. Ben has years of experience in the development and implementation of strategies for protection, management of portfolios worldwide, and the execution of programs for different famous brands. Frequently, he's called to represent clients in disputes in international brands, and he also has a broad experience in industrial designs. This panel will be a conversation. There won't be any slides or any presentations, so we would like for the public or the audience to participate in the Q&A and the different focuses, just to let us know which are your topics and your doubts. We hope it is interesting, and this is a panel that was made with full enjoyment. So, Carolina, which are the options of the clients or in-house to protect designs, industrial designs in the European Union, Colombia, or the United States? Well, good morning to all of you. Thank you, Laura, for your presentation, and thanks, ASIPI, for the invitation. In Colombia, or within Colombia, the design protection is done through a registry that is given to a term of 10 years, not more. It's a unique protection once. This registry is required amongst the Superintendency of Industry and Commerce, which is the local and competent entity for this, and it has a simple tremit But the most important part is to be able to test the two fundamental requisites of the design: how novel and how original it is. Novel in the sense that the design hasn't been seen before, and how original it is in terms of how distinctive it is, the capacity of being different. To verify these two elements, there is a previous stage that consists basically in making a look of backgrounds locally and outside. And if you look at the protection of the design, it's locally only for Colombia's territory. It could happen that previous designs from other territories could affect the originality or the novel, or how novel the design is. But it's very important that look for that background, which is technical. I believe there's an important stage for the person that is interested in the design, and it's verifying in the market with consumer and competitors how that design have the capacity to really represent an advantage amongst the market. It's important to make this revision, or on the contrary, we will attain possibly the registry of a design, we will have a protection, but for the person that is in charge of the brand won't have a real advantage in the market. So we need to make a deep study that allow us to determine if for that designer, for that person that is owner of the design, it represents a competitive advantage, if it will have an identity of brand, which is possibly the interest, or if there will be a return, an economical return. That's a way of protecting in Colombia without going into the detail of the registration procedure. Thank you, Carolina. Very interesting to see the point of view of Lending House. But Ben, same question.
Teams have for protecting designs in the U.S.
There's actually three main options. So the first is copyright, which the U.S. is unique, where we have a copyright registration system. It's actually only necessary as a prerequisite to filing a lawsuit. Some people don't realize that, but many in-house teams use the registration as a way to keep track of the dates of creation and the authors and essentially who's done what. So that's a very common for in-house teams in foreign countries to use the U.S. Copyright Office as almost a depository to keep track of their rights. The second option is, which is also many people are unfamiliar with it, is a trade dress registration. That can protect product design, non-functional aspects of product design similar to a copyright, and it can also protect the product packaging, which is slightly easier. Both of those options are, in many instances, better than a design patent. A design patent, which is what most people are familiar with, it also protects non-functional elements of the design. However, the actual scope of protection in most instances is not much different from what you'd get on a trade dress registration or for a copyright. It also takes much longer and it's more costly.
Okay, thank you very much. Iván, la misma pregunta para ti. ¿Qué opciones tienen?
Ivan, same question for you. What options do the in-house or the legal teams have to protect designs in the European Union? Well, talking about European Union, the first thing we must take into account is that it's a union of countries. Therefore, I'll give a slight introduction to understand correctly the system, and from there on be able to suggest determined strategies. When we talk about design in general, protection, and I coincide with my colleagues from the panel, it could come from the hand of industrial design, properly known as industrial design. In some other territories it's called differently, like in the United States, but we know what we're talking about, the brands, the copyright. And even if they were functional features, we would go into the limitation of the patents, well, models of utility, and others. In Europe, there are two legal frameworks that we must understand, and it's important to understand this to be able to determine adequately the strategies of protection. On one side, we have the directives that simply tell the member states how their legislations should be, which is the minimum that they have to fulfill. And on the other side, we have the rules that are normativities that apply for all the European Union. In the case of design and going into industrial design, we have a design directive, and we also have a design rule. This ruling in design contemplates two options: the registered design, where you acquire the right through the registry, and it could be extended up to 25 years. It can be given for 5 years, and you can extend it up to 4 times. And the other one is the communitary design that is not registered. This is a legal figure that gives a protection of 3 years from the first publication without the need of any registry or any copyrights. In the environment of protection of design, this could be extended to any design that doesn't generate a different impression of design. This is important in terms of determining the strategies of protection, because depending on the nature of the products or the goods we want to protect, we will need to go to one figure or another. It's not the same, the environment of protection and copyrights, than the one of the design or brand. Therefore, we have these two options: registered design and the non-registered design. There is an office of registry. Originally, it was called OAMI, and for certain years it's been called a WIPO, where you register brands as well as designs, communitary designs. That will be called European designs with the new legislation. If we have some time, we can talk about this. And as well, there are some specialized courts or tribunals. The decisions of the office, and now we will see why it's important to understand the system as we're explaining it. The decisions of the office can be revised and appealed towards the end by some tribunals that are in Luxembourg, by the General Tribunal or the Justice Tribunal of the European Union. And this one of the European Union can determine with criminal rulings, may make an interpretation of the sense of the directives and the norms. Now, what happens is that just recently, the Tribunal of Justice of the European Union has taken a decision in a topic that is known by COFEMEL, that surely you have heard about him. And it's a litigation that was done between a company that is called Gestat, that made jeans. And very shortly, the demand was due to the copy of those pants. The Tribunal of Justice was, asked if this industrial product could be considered as a work, and they also asked, in the case that it was considered as a work, which would be the requisites of protection. What the tribunal mentioned was essentially that it could be, even if it's an industrial product, considered as a work, if it talks about non-functional elements, just as Ben was mentioning before, and if, and always if, it was original, in the sense that it was the outcome of an expression and the personality of the author. So it approximates the criteria to the criteria of art union, which is traditional from the French kind of knowledge. Now, after this decision, there have been some other decisions in European countries. For example, in Italy, in Milan, there was some cases that considered these boots with a lunar form, and now they start talking about copyrights. In Belgium, in terms of handbag, Longchamp, recently, and in Barcelona, in terms as some lights that are called Latin lights. So we must consider how there are decisions from different countries which protect some creations that traditionally are industrial due to copyrights. With this, we go into the strategy of protection. This is what happens with these maps and possibilities. The strategy of protection will depend on the nature of the good. It's not the same to talk about a collection of Botero, now that we're here in Medellín, than to talk about shoe wear, glasses. So we will have to play between the registered design or non-registered and the non-registered. With the test of divulgence, we will have to ensure this test to be able to attain a right and be able to compensate it when it's possible with topics of copyrights. Thinking in COFEMEL, for example, the COFEMEL doctrine So the contracts, when you hire in-house designers, external or internal, you will need to accredit that these are original creations and start originating this kind of testings to be able to eventually use this tool. And even if there are copyrights, these ones are attained due to creation, and towards the end they have some distinctiveness in knowing if it goes into local brands or not. So what happens with the partial designs? It's a bit shorter. I mean, I know that I extend myself in this first question, but Europe is a complex environment. So partial designs, the concept of design in Europe protects the product as well as part of a product. The rule is very clear in this sense. Therefore, you may apply or you may request a protection for a partial design for a part of the product, for a portion of it. Now, there are some common practices, which are documents that are emitted by the WIPON with a collaboration with local or national offices that tells you which are the best practices. There's one that is the CP6 that talks about the graphic representation of designs. And over there, we might find how the techniques can be of blurring or darkening, but the favorite one is the broken lines, the uncontinued line, to be able to represent the partial designs. Now, just to mention, related to what has to do with the practice of protection, and the environment of protection is the same, it will be extended to any other portion of the good that doesn't generate a different impression in the usage. But there is another decision through the Tribunal of Justice that must be considered that is very recent, and it's related to the parts of Ferrari, and they demanded Monsori due to the copy of the design of the front part of the car that is covering the engine of the vehicle. Therefore, the German tribunal, the Supreme Tribunal, asked the Justice Tribunal, this topic of the non-registered design applies to the partial designs, and if it applies, how should the protection be? What the Justice Tribunal says is that it does apply. The non-registered design can be applied perfectly to a partial design. And two, not necessarily will this partial design be divulged in a separated way to the complete good. So in this case, it's not necessary from the vehicle completely. Nonetheless, here we have the tricky question. This portion has to be perceived in a clear, identifiable way by the users, that it doesn't get lost in the globality of the product or the vehicle. And that's the part that is much more difficult to read or understand. Nonetheless, SICAP is another tool to be able to record the techniques of design in terms of the design of these goods.
Fluent at understanding Spanish. I would like I would like you to comment about what are some of the common issues and or misconceptions that arise with Latin American entities when seeking to protect their valuable designs under U.S. law.
Well, so I touched on this earlier. So the main thing is that the design patent is not really the only option. And if an in-house team or a client is looking to protect, going the way of trade dress under U.S. law, which kind of loosely translates to a 3D trademark in other countries, making sure that filing it's quite complicated. So it's not something that will do well through WIPO in most instances. So there's a secondary register, just to focus on the trade dress registration for a moment, and that's for descriptive trademarks capable of acquiring secondary meaning, which is ineligible. So Madrid designations don't qualify. So many of these trade dress applications would most likely end up on the supplemental register, which is reserved for nationally filed applications. That's a first major issue if a client is looking online and sees the possibility of a trade dress registration, something that should really be filed nationally. To qualify for a registration on the principal register, you need a showing of acquired distinctiveness. So that can be through fame, so it translates to under EU law to fame, but you can also get that from 5 years of consecutive use in the United States. So as an example, many watch companies get trademark, trade dress registrations, and the design is not necessarily famous. It's through 5 years of continuous use in the United States. That's one major issue. The second misconception is the actual value of a copyright registration. It's needed prior to filing a lawsuit in federal court. So it's not something that, aside from using it to keep track of what you have and or what a company has and keep a record of it, it's not something that's really necessary. It can be nice to include in a cease and desist letter. But under U.S. law, anything that's written is protected. That's eligible for copyright protection is protected as soon as it touches the paper or the computer screen or whatever it is. The third misconception is really the value of a design patent. So they're not examined, unlike a utility patent. They're not examined against prior art. So the examiners are not doing a search. So that design patent might not be able to be enforced. And that's something that comes up all the time where, especially now with Amazon, you might have a client that has a hot product on Amazon and these people are pushing these design patents, and it's what is the actual value. They might be able to monopolize Amazon, but if they tick off the wrong person, that patent can be invalidated.
Okay. Carolina, después de...
Caroline, after listening to the focus of these two attorneys of different firms, your work is to coordinate external attorneys. So which would be the reasons for which the industrial designs are important for your industry? Well, the maximum purpose of a businessman is to be relevant in the market where they participate. That's what a businessman looks for. The reason of being of the work of the businessman is that the consumers of their market prefer them above the competitors. The way to do this is being different. If the businessman is not different, they don't do different things, they don't have different products, the consumers won't prefer them. That's why the designs play a very important role, and the role of the design is very important for these businessmen, because the businessmen always try to differentiate in different ways. Sometimes they try to differentiate through a price that is very low. Some other times they do it with quality. They have products of excellent quality or great performance. And some other times they will try to make the consumer to connect with their brand from the DNA, from what that brand wants to project, what values they want to show the consumer. It happens with brands that are quite close to sustainable development, that are concerned about the environment, to protect different elements of the environment, equity, diversity. And there are other categories of products where the appearance of the product is very important. That aesthetic appearance is very important. So the businessmen sometimes bring together all these elements. For example, the hard discounters always bring together excellent prices and great performance of their products. A brand like Apple has been able to bring together topics of quality, great performance, but also design. Concretely, in the market of massive consumption of cosmetics, the form of the product, the aesthetics, is relevant for the consumer. The consumer is not only looking for a product that has a great performance, that accommodates to their skin, that it doesn't generate allergies, but what the consumer also looks is for a specific aesthetic presentation that is given to the trends, to what they see around the market. So in the sense that the design allows the businessmen for third parties to use similar designs or to copy their designs, gives them that distinction and promotes their advantage in terms of competition. So what the designs do for the businessmen is that it becomes them relevant. Okay, may I jump in? Thank you. Carolina, what you're mentioning is very interesting. And aside of this, in your sector, forms. For example, a cream starts acting over a person emotionally according to the form of the vase that contains them. You have them in your bathroom, and if it's attractive, it seems that it will generate a more positive effect, right? And it is true that in front of products that have the same price and have the same function, it's the form of the package that incides in the purchase of the acquisition on behalf of the consumer. And in main industry, that's a way of innovating. Yes, and there are brands that have cheaper products that any person can access them, but they precisely want to evoke that feeling of luxury that a brand has, a brand, for example, that is in the top of the pyramid. And that's what the consumer feels, that with a low cost, they can buy a product that makes them feel as if they were buying a luxury product. Yes, and towards the end, the form of the vase gives a message. And when we talk about protecting the design, it's precisely the topic of how to protect that message. And towards the end, it's not so important if it's through a figure or another, but to protect that message and to protect it from that people that we don't want to take that message away, and that sometimes building that message takes a lot of effort. And you also have 3D brands and designs. Do you use the three figures? How does an in-house take the decision of which path to follow? In these cases, it's very important to differentiate if the design or that aesthetic design really identifies the product or the brand. Does it identify that business origin that we want to identify? And depending on this condition, the decision will be taken if it's protected through design, via brand, or if we can obtain the two types of protection in a determined case. Ivan, with what you mentioned, you said that life in Europe is changing. There are certain decisions changing, certain rules. Could we go more in deep in this topic? And what will the practice modify? Well, last week it was published. Well, they published all the drafts of the future directives as well as the rule set. And this process of consultation already has had some time, where users, through organizations of users, have participated and contributed to these changes, and now these drafts are published. Now we will start with a process that ideally would finish on the second semester of 2023 under the presidency of Spain, where we approve the directives and the rulings. But our feeling is that it could take a bit more. So the main changes talk specially to evolving the concept of design and the concept of products from the current texts to embrace all the topic of digital designs. There are other changes that we will be talking about, but related to this, there are three topics that I would like to highlight. The first one is to evolve the concept to be able to protect in a more efficient way the designs and movement that are done based on static images of different positions. The topic of 3D printing is also affronted bravely, and it will consider if an infringement of design, the usage of software, the download of software without the authorization of the main person of the design, especially focused to the users of content and intermediates and end users that take it without any permission to be able to make their 3D printing. And then there will be a chapter of limitations for those that want to create a design through 3D printing, but not taking or copying the software that generates it. We'll see how this ends, but it's being affronted courageously. This option has been applauded strongly. And then we have the metaverse and this topic of digital designs, where basically the European position and the development of the practice here has been that the environment of protection of a design in Europe that is not determined by the indication of a product that is selected in the request, but there's a tricky element that we must consider, and we need to talk about this later on to see which is your perspective, because even if we see it like this, but if afterwards a design of yours is copied, you have to understand if the general impression of the design is the same in the informed user, because the informed user could not be the same in a digital good and a physical good, for example. So from the point of view of the users, when we have been making requests of design of digital products that are destined to the metaverse, what we have procured is to make different product invitations, and this was limited. In the WIPO, we had some difficulties. This will also change, and it will be more flexible. So we have these three topics in digital designs. Afterwards, we eliminate the requisite of visibility for the component parts, which is okay, because it was a requisite that only affected the parts or the components while they were being used. The regulations said that they had to be visible in normal use of this product, and this opens a very interesting field in sectors of in car industries in terms of the components. We will be following the infractions of the products in transit that don't have a destination within the European Union, and there will be an update of fees, and probably the directive will include the need for all the office of the member states must give or provide the possibility of canceling designs from the point of view of the administration, just as it happens now in the WIPO, where you can go to the office and present an action of nullity without the need of going into a justice tribunal. Now,
Now, these tribunals with the current norms can see design cancellations directly or as a result of a counterclaim. So basically, when you request that they reassign this, the national systems will adapt to the way that WIPO works. And something else, it seems like there's an adoption of the Cosemel doctrine, of the author's rights principles, which is incorporated to some extent already, but we're just confirming that that is the definitive doctrine. Those are the fundamental changes, in essence, to adapt to that new European law.
So, if all the changes that have been happening in Europe, my question would be, what is a trade dress and the product design registration under U.S. trademark law, and how it's dissimilar from a design patent?
Sure. So the trade dress product design registration, that's technically it's a trademark. It's something that's interesting about it is it's actually not enforceable absent a showing of fame. So historically, courts almost favored someone seeking to enforce their trade dress doing so without a registration, because the court would ultimately decide on whether or not that design is famous. It's actually a very useful tool, perhaps in Latin America as well, because, for example, a trade dress registration could possibly protect. I had a case, and it was the layout and design of a store that was quite famous. And you can immediately go into court once a client decides to go ahead with a lawsuit based upon these common law rights to the trade dress. So it's really something that not many people are familiar with in foreign countries. We tend to get many requests for these design patents, and sometimes we question what the value is. Design patent correlates loosely in most countries to an industrial design registration or the registered community design. As I mentioned before, they're not examined against prior art, and they're significantly more expensive than, in most instances, than acquiring a trade dress registration if a client even decides to obtain a registration. But the first thing that happens if a client seeks to enforce a design patent is it's going to be challenged based upon prior art. But very useful tool to just alert your clients to, or for in-house teams. And we're probably over the last 2 or 3 years, we've seen an uptick in foreign companies requesting, that if it's a bottle for tequila or gin, we've been doing a lot of these, and It's a nice result. It's also visible at the trademark office, right? So if an in-house team wants to send its own cease and desist letter, you can download that registration and share it. So it's a nice kind of clean option.
Of course.
Sorry, may I ask you a question?
Sure.
Imagine an iconic product, a bag or a shoe that becomes iconic. Would you go for trader's registration or 3D trademark?
You mean for a patent, right? Yeah, so the issue is the 1 year bar from when the design would have been made public for filing a design patent.
No, the design has been disclosed, so no, that option has been removed. I mean, would you go for 3D trademark or trade dress or?
So we would do I would likely recommend a trade dress registration, which translates from a 3D trademark. If you were to designate the United States through WIPO, that 3D trademark would be, would reach the United States and it would arrive as a trade dress application. So that's what we'd recommend, and a copyright for non-functional aspects of the design. In most instances, as you point out, the eligibility for a design patent no longer exists. So something else is many times clients will be anticipating, they're being optimistic that their design is going to be super famous and it's going to be a big hit, and it's not. So that's why also a copyright and trade dress registration, they're nice options.
Ben, again, you. We understand that the U.S. Patent and Trademark Office relies heavily on the use in commerce. Are there any mechanisms under U.S. law that make it possible for foreign entities to protect designs absent of showing of use? Are the rights obtained enforceable?
Sure. So provided that a company has an intent to use that mark in commerce, we can rely upon a home country registration for the identical, if it's a 3D trademark in that home country. The key is the entity really has to have a bona fide intent to use that design. Otherwise, even after registration is issued, it can be attacked for up to 5 years, actually. So that's a major thing, really, with foreign companies. The USPTO is that's a really strict requirement. Bona fide intent to use if you're taking advantage of the loophole to rely upon a home country registration. It's questionable whether or not the trademarks are enforceable. You're really better off enforcing them, or the trade dress registrations, better off enforcing them after the design has been used. So that's really what we recommend.
Okay, thank you. Carolina, después de que has oído lo que nos han comentado, Iván.
Carolina, after hearing these comments, what are in your markets the most used elements or forms? What could you share? What do you think is happening? The common use elements in the product categories are elements which usually share the products that make up the category. It's what the consumer is expecting that category to identify, and this is why these elements help to identify a category. And so in toothbrushes, they always allow, for example, in oval shape and handle, which used to be certain materials and today is changing a little bit, and it always has a grip area that allows us to use the toothbrush more comfortably. If we think about formulas for children's milk, the packaging is always similar. We're always expecting the same thing, because within it there are also certain shapes and forms that allow us to extract the milk in a certain way. And if we think about not just shapes but colors. When we stand around a women's deodorant, in front of women's deodorant, we usually expect the same colors, pastels, pinkish colors, white. But if we stand in front of a gondola of men's deodorant, we'll find a different set of colors: blacks, dark gray, silver, blue, red. This is what they are expecting. And when this isn't done, then the product doesn't have success because they expect to find that. So we cannot leave that formula. And we might think that these elements are contrary to the fundamental characteristics of the design, because the design protection looks for novelty and originality, but the elements of use are usually habitual. They allow us to identify the product category, but the design identifies a specific product within the category. So it is quite common for businessmen to question, if I have those common use elements, if I share those elements in my product, can I still have protection to my industrial design? And the answer is yes. It's just that regardless of the use of common use elements, there has to be a distinctive characteristic to the product, and this is how I can protect them. And so we protect the entire unit, not the individual parts. So even in Colombia, you can find competitors who share certain elements, but within the category, they have industrial designs registered in the forms of their packaging that identify their specific products. Now, I'd like to know your opinion on this, Iván. It's very interesting, because in Europe, I think we are very much following that criteria. The response is the same in terms of whether it can be registered. You can always register a design so long as it's new and it has a singular characteristic. That means that it generates a different impression when compared to the other known designs. And so it can be registered. It's just that the protection of the design is limited by the liberty of the author. This is where these concepts apply. And the author has a level of liberty that is more limited when it comes to the toothbrush, because it has to have certain elements in a certain use or a certain manner for functionality reasons, and so their distinction lies in characteristics that aren't necessarily purely functional. And this is where we start to talk about that protection of design. And I'm just recalling a case that there was in Europe, which was the Karen Miller case, regarding an article of clothing that someone was trying to cancel that registration, and they were trying to do so bringing different characteristics contained in different designs. Because this button is in this design, this pocket isn't in this other design, this certain thread or elements, and what was said by our oracles or the interpreters of the laws was basically that the guidelines are clear when they say that a design must be compared to another design, not loose characteristics contained in different designs. And so this is, I think, a stable criteria with respect to what you've already mentioned.
And designs, and how in Europe it has been interpreted. In which way when case of enforcing rights and infringement, how do they compare the designs, piece by piece, the designs as a whole? How is the comparison when enforcing the rights?
Essentially trying to extract the non-functional design elements from the designs. Usually for design patent infringement, the cases that you see in the news are, they're normally able to find prior art, so similar designs that existed in most instances as a gross generalization. But they're trying to find the new decisions. I don't think they use the word separable, so you're not really supposed to say it, but for the purposes of explaining it, design elements that are separable and non-functional An interesting way of looking at it is many times when we're taking a functional object that has an intricate design, we go for a copyright, we try to categorize it as a sculpture. So that was what was a good strategy for many years. Most recently, Copyright Office, I don't think they love it, but we got, as an example, for a large company, it's quite a famous brand. We did a program to protect, tons of their designs. I think it was like 300. And the examiner at the Copyright Office took, on their own initiative, went through and tried to categorize these design elements as functional. And we were able to get them all through, but it's not, to answer your question, you should be looking at separable elements, but it's not like a clear path. There's no real great answer. So we warn clients in advance, we're gonna try for copyright, trade dress, whatever it is, but it's not, you might get an examiner who doesn't view this as distinctive or, non-functional.
Okay.
Yeah, because the overall impression of the design is given by all elements.
Yep.
Not only the non-functional, but also the functional. So it's difficult to reach a clear comparison.
It's complicated, especially with clients that have a registered community design, because there's more academic decisions that are accessible, and clients are looking at those and seeing the decisions, and we don't really have that in the United States. So the decisions on that would be decided at the district court level, really, for a decision that kind of mattered and carried some weight, and there's just not that many of them.
Yeah, reading the U.S. decisions, they normally use the expression "figured out," that these functional characteristics must be figured out of the comparison. No,
Yeah.
I don't know if you're still using that.
I think the most recent decision, if I remember correctly, is from like the year 2000, and that's sorry, this is on a trade dress registration, and what they did was they separated product packaging, product design, and then they went through and tried to set some guidelines for analyzing it, but it's not necessarily that different from a design patent.
Okay. We have like 15 minutes left, and to wrap up things, I would like to speak about the future. How do you see designs in the metaverse, Ben? What is going to happen? Which is your opinion, your just suggestions of how to protect and enforce what is going to happen, because we have it here. It's coming, or it has already come, and our audience would be very interested in listen to your opinion of what's going to happen in the future.
Sure. So I think there was a decision for Mace. I think it's a few months ago, but I think that in the United States, courts are going to continue to really take a strong opinion that physical goods are inherently related to virtual goods, and that's kind of going to be the end of it. However, I think that clients are still going to feel, obligated to be on the safe side. In-house clients want to file to protect all of these virtual goods, and we kind of struggle with we have these very strong use requirements, so we're protecting the marks in connection with cryptocurrency, everything you can think of, and we don't know really if a client's going to be able to figure out how to establish use. The USPTO is coming out with new guidelines and recommended descriptions of goods and services. It's going to be available online. If it's not, I think it might be already the preliminary proposal. So it's interesting, but I think that courts are going to continue to really clearly make it clear that physical goods are related to virtual goods. And I saw there's a number of decisions in Europe, right, that say the same thing.
Venimos a ti. ¿Cómo está la visión europea de diseños?
What's the European perspective? It seems that, well, first we don't know what will happen with the metaverse. We'll see what path that takes. as a personal opinion, I'd like to say that I expect we won't stop seeing each other eye to eye and sharing in a glass of wine. I'm more mundane in that regard. But returning to the metaverse, it seems like the trend is that the protection of design will embrace digital aspects, and thereby we won't have to double protections. I think we all agree that it's absurd to have to double protections in the physical world and in the digital world. It's at the end of the day, it's an unauthorized use of our design, and it should be simpler and, how do I say this, more available to users to be able to defend these types of situations, not have to require registrations with in classes with different trademarks. It's a use of your brand and your design. I think that the solution should be simple and definitive. Now, in Colombia and in your sector, how do you see the metaverse? Are you ready and planning? Now, first, I agree that this protection should be much more agile. And the challenge for us within our companies will be to make it so that the people who really put the product in the metaverse, that they digitally have that ability to place the product in the digital world, and that we're able to understand that these are assets of the company, that they're not different from the physical product that we're putting in the market. I think that's where the largest challenge lies, that we really have that culture of protecting intellectual property. Because if it's difficult in the physical world, in the digital world, I think it'll be much more complicated. I think this is what we had prepared. We'd like to know if there are questions to any of the panelists with their different jurisdictions. I don't know if there are questions from the audience. We don't see anything from here.
Acá tenemos. Sí, buenos días. Bueno, la pregunta.
Good morning. Now, the question is for Carolina. I agree in your statement that design has become an important factor in purchase decisions, and I think this has gotten to a point where the engineering, which was that aesthetic factor, but there are artistic matters that have an impact on this, and functional ones, and this leads to maybe us ignoring traditional rights. In Europe, there's the opinion that we're using that 3D brand to protect things that should be a design matter, the legal life that we should be able to prolong. Is this happening? And if we have the situation of not having a distinctive capacity, if it's viable, before the end of the design life, we should be able to maintain this. And if the same thing happens, I think we experience this situation and we have that shorter protection, only 10 years of protection is very little time in a design. In the sector that I have experience in, there's something interesting that happens, which is that the design is so changing and the consumer is so changing. We expect people to be generating new trends. And when the protection of the design ends, often I don't even use it. It's no longer interesting to me. And so for us, it becomes, the initial protection becomes fundamental in cases where other types of rights are involved, or even authors' rights. we'll need to have the corresponding controls seeking to obtain more protection time. But in my experience, it's not so relevant since we have to change the appearance so much. The protection could be relevant for longer, but in mass consumption, in very little time, I can't even use the designs that I have protection over. Are there more questions? No? Okay. If that's it, then we conclude this way. Thank you, Ben. We hope that you've enjoyed these 3 perspectives, and the panelists and I are at your service for anything you may need.